Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss a contempt case against a Deputy Director of Tribal Welfare in Andhra Pradesh High Court. Chief Justice, Justice Ravindra, Honorable Justice Ravi Nath Tilhari, while dealing with the case of P. Satyanayana Reddy versus M. Saraswathi. She is the Deputy Director of the so-called Tribal Welfare in AP. Right? In contempt case number 1032 by 2019. Decided on 7/11/2023, held that, this is more important, the Honorable High Court held that paper apology can't be accepted. Paper apology cannot be accepted in contempt cases. Why? Normally, it is, I think, general practice or habit. Even we have also faced the same thing. At the time of promotions, the troubles will come. So many ACRs, so many suspects, so many things they will discuss, and ultimately what they will say is you are not fit for promotion. The rules say that ACRs should be proved beyond all reasonable doubt, annual confidential reports. So many things will be there. So when one person is not given promotion, normally it is the tendency of the government officers to approach the court. When they approach the court will ask the concerned officers normally to consider or to reconsider the case. But they don't care. Sometimes directions will be given that he has to be appointed. His services, they have to be regularized. Like that, the courts will give direction, but the orders will be thrown in the dustbin. Ultimately, the person will keep quiet. He will definitely go to the court once again and say, Your Honor, my Lord, your instructions or your directions are not at all followed by the concerned officer. Then the trouble comes. Then it will be taken as a contempt. And in contempt cases, you all know that these people, the officers will approach the court and tender unconditional apology or paper apology. Right? Now, in this particular case, please remember, paper apology is an apology which is hollow. Khaliga undi, hollow, with no remorse, with no regret, or with no repentance. It is only a device to escape from the rigor of the law. See how beautifully he has written. So just like if you say, I apologize, I am feeling sorry, this is not acceptable, paper apology. Why? Because the court has taken it very, very seriously. So, Mrs. Saraswathi, M. Saraswathi, who is working as DD Tribal Welfare, she has been, a contempt case was initiated against her under Section 12 of the Contempt of the Courts Act 1971. You may be knowing, right? Actually, this Satyanayana Murthy, as when he approached the court, Honorable Court directed Saraswathi on August 14th, 2019. August 14, 2019, they have given directions that the petitioner's request should be considered. That means he has to be appointed, right? But the Tribal Welfare Deputy Director, she has been delaying the matter. She did not comply with the court order, stating that she has been waiting or she needed a clarification from the Director of Tribal Welfare before considering the case. And ultimately, she rejected the case. But when the matter is placed before the Honorable Court is satisfied that the Deputy Director has got enough information before her. Necessary information to consider the petitioner's case. Her delay in doing so was willful. She has willfully neglected the court orders. So, Deputy Director, the apology of the Deputy Director is not bona fide. She has acted deliberately to subvert the order. The court noted that the DD's apology was not genuine and their actions were deliberately intended to thwart the court order. Right? The court, please remembered the very famous case. Jhareshwar Prasad Pal versus Taraknath Ganguly, 2002. Second case, Kapil Dev Prasad Shah versus State of Bihar, 1999. So please remember, here what happens is they are under the impression. We have seen in so many cases, suppose if you go and show the orders of the High Court, please appoint him, please consider his case, then they will not care. Oh, you go to the High Court. You are so great person to go to the High Court and get the order. Who cares the High Court orders? Throw it to the dust. We don't care. And when the matter is taken as a contempt, they go and apologize before the court that they are very sorry. But the actions, one means the evidence submitted by Mr. Satyanayana Reddy, they are quite contra to the apology letter given, affidavit given by Saraswathi, because she might have told him something. Nowadays, they might have taken a photo or videograph, arrest ipso lacto, these things would have happened. So, as officers, once again, it is cautioned that please, you have to implement the High Court order. Don't wait for the orders of your superiors. When the information is with you, no doubt you can consult your officers, you can take your own time, but you have to give some finality to the representation of the person. If you don't do it, definitely you have to face the contempt case. So in Andhra Pradesh, it is a peculiar feature, or it has become a general feature, that the officers, they are attending the High Court. Personal attendance is there. They are facing contempt cases. So as an IPS officer, as an IAS officer, who are the eminent people of the society, highly intellectuals, you are going and standing before the court of law and requesting for apology. What is this? Have you performed your reasonable duty? Dedicate statutory duty. You should not have you should not have to cut a sorry figure before the court and get the so-called strictures from the court. It's not proper. This is what I want as an elder, what I want to advise you. As advocates, please study the case law and enrich your legal knowledge. With this, I am stopping here. Thank you very much.